This case unfolds as a collision between court authority, personal crisis, and repeated defiance of legal obligations. What begins as a routine child support compliance hearing quickly escalates into something far more revealing. At the center is Chelsea Brink, homeless, recently hospitalized, and already thousands of dollars in arrears standing before a judge who is no longer asking if orders were followed, but why they weren't. Within minutes, the court is forced to sort fact from contradiction. Claims of hospitalization clash with employment requirements. Assertions of poverty collide with records of a recent home sale. Emotional explanations are offered, withdrawn, and then reframed again, sometimes mid-sentence. And as frustration builds, the judge repeatedly attempts to restore order, reminding Ms. Baudo Brink that court is not a negotiation, and obligation does not pause for circumstance. What makes this case compelling isn't just the numbers over $10,000 owed here, $13,000 there, it's the pattern, missed applications, partial payments, conflicting timelines, and ultimately, a deeper legal question. When does hardship explain non-compliance, and when does it become contempt? Stay with this case closely, because by the end, it expands far beyond child support into criminal charges, bond decisions, and a stark reminder of how quickly courtroom patience can run out.
The next matter is Devin Hildebrandt and Chelsea Brink. That's file 11-14050-DS. I do see Mr. Hildebrandt is here. Do we have Chelsea Brink with us?
Yes.
Could you put your video on, please, Ms. Brink?
I don't have that capability, sir.
Where are you at right now?
I'm here via phone.
Where are you physically located at right now?
The Comfort Inn and Suites. I got a room here last night. My dad gave me $1,000.
What type of phone do you have that doesn't have video capability?
Galaxy something. It's an Android device.
All right, and you didn't download the Zoom app? You're just calling in?
No, I'm connected via phone. That's the best I can do, Your Honor.
Ms. Kraus, is this your matter?
Yes, for this case with the Hildebrandt, yes.
All right. My order last time was that Ms. Brink submit documentation about job.
The judge's first concern is compliance, not sympathy. The prior order was clear, 10 job applications per week submitted to friend of the court. There's no ambiguity here. When the case manager confirms that documentation was never received, the legal burden shifts immediately to Ms. Brink to explain why. What follows is important. She interrupts repeatedly, and the judge shuts it down fast. This matters because interruption isn't just poor courtroom behavior, it weakens credibility. Judges rely on order to assess truth, and when a party talks over others, it signals emotional escalation rather than factual rebuttal. Notice how the judge responds, calm, firm, procedural. He doesn't argue the truth of her claims yet. He enforces structure first. That's deliberate. Courts cannot evaluate substance until process is respected. This moment sets the tone for everything that follows because from here on, every explanation Ms. Brink offers is weighed against a growing pattern of non-compliance.
About job applications, she was supposed to do 10 job applications each week to the Otsego County friend of the court. Has she done that?
She has not. There was a voicemail that was left in regards to a couple concerns that were outside of employment issues that were outside the scope of friend of the court. That message was left for the other case manager.
That's the most untrue statement I've ever heard in my life. My voicemails were regarding job applications I submitted.
Ms. Brink, I will get to you in just a minute, but you don't get to just interrupt somebody else that's talking. I can't have a conversation with one person if somebody else is talking over that. You will have a chance to say what you need to
lies about me.
Ma'am, you will have a chance to say what you want to say in a minute, but I need to talk to people in order, and it's not your turn. If you're going to do that in the future, I'm going to require you to be here in court, and if you're going to be here in court, you're going to behave yourself just like you would when you're on the phone. You understand that? All right, Ms. Kraus, go ahead.
Yeah.
As to the voicemail and the contents, it would be more appropriate to speak
Here's where the math becomes unavoidable. The case manager lays out the numbers clearly. A $197 monthly obligation, over $10,600 in arrears, and only 2 partial payments received months earlier, less than $50 applied to this case each time. From a legal standpoint, intent matters less than outcome. Courts don't assess whether someone meant to pay. They assess whether payments were made and whether court-ordered steps were followed to change the obligation. Without filed motions, documented income changes, or verified inability to work, the obligation stands. Mr. Hildebrandt's testimony reinforces this point. He confirms minimal payments and long gaps. That corroboration matters. When both the court record and the recipient align, the burden of proof shifts decisively to the obligor. This is the moment where explanations must become evidence, and as we're about to see, that's where things begin to unravel.
To speak to the other case manager, her obligation is $197. The arrears for this specific case is $10,604.42. The only payment that's been received was a payment in April and May. $100 was received, but $49.37 was distributed to this specific case each month.
All right. I do see Mr. Hildebrandt is here as well. Mr. Hildebrandt, have you received any child support payments from Ms. Brink?
No, sir.
When was the last time you did?
I want to say it was in May, and it was like $45 or something.
All right.
I think I might have received 2 payments possibly. And
Same
that
ones that Ms. Kraus was just talking about?
Yes, sir.
All right. All right, Ms. Brink, please tell me why you have not done the 10 applications per week and submitted them to the friend of the court.
I've been in the hospital.
Ms. Brink now introduces hospitalization as the reason for non-compliance, but listen carefully to the details. Dates shift. Facilities change. Reasons remain unclear. At one point, she says she doesn't even know why she was hospitalized, only that the judge ordered it. That statement immediately raises a red flag. Judges do not order involuntary hospitalization through child support hearings. If law enforcement transported her, that suggests a separate legal or mental health intervention, not a family court directive. The judge begins probing specifics: when she was admitted, when she was released, and whether any documentation exists. This isn't skepticism, it's due diligence. Courts require verification. Without discharge papers, medical records, or formal motions to pause obligations, hospitalization alone does not erase responsibility. This is where narrative explanations collide with procedural reality, and the court starts narrowing its tolerance.
For the last month, you ordered it.
I ordered you to be in the hospital for last month?
Yes. The police came to my house and said they had an order from you saying to go to the hospital. So I went to the hospital with them.
Which hospital did you go to?
Well, they took me to Otsego Memorial Hospital emergency room and then transported me to D6 at Munson in Traverse City after that.
When were you
So I've been in
released
the
from the
hospital
hospital?
for the entire month, but I did submit applications to a few places. I left a voicemail on front of the court and the prosecuting attorney's voicemails saying that I did that. And I had a job interview at Taco Bell yesterday, but it's really just not. I'm in a ton of pain. I've been in 2 car accidents, and I'm homeless. So getting a job and making child support payments is not at the top of my priority list.
Really?
Although I know it is at the top of yours because my children need support, but I just can't right now. And I apologize for that, but there's just really nothing I can do. I don't know what to do. Nowhere seems to be hiring.
This is one of the most emotionally charged moments of the hearing. Ms. Brink openly states that child support is not her priority because she's homeless, in pain, and struggling to survive. From a human perspective, that's devastating. From a legal perspective, it's insufficient. Courts do recognize hardship, but they require action alongside it. That means documented job searches, engagement with housing resources, and formal requests for modification. What the judge emphasizes here is crucial. Obligation does not disappear because circumstances are difficult. Notice the judge's solution-oriented approach. He directs her toward community mental health, housing assistance, and rescheduling appointments if necessary. This isn't punishment, it's an attempt to stabilize compliance. But every time guidance is offered, it's met with resistance or contradiction. And that pattern begins to shape the court's next decisions.
I'm doing the best I can, to be honest with you.
Ms. Brink, what were you in the hospital for?
I don't even know. You ordered me to go to get checked out. That's all I know. And they sent me to the mental health. I guess supposedly it's a mental health unit.
When
This
were
is
you
not the
released
first time
from,
it's been ordered.
when were you released from the hospital?
2 days ago. I'm going to Petoskey's Mary Margaret house today to sleep on their couch. That's the best they can do. I have nowhere to go. And if I do that, I'm going to miss out on the Taco Bell job, but I don't know what to do. It's either that or sleep in my truck, and I can't keep sleeping in my truck.
Do you have a community mental health caseworker, Ms. Brink?
Supposedly, I don't know. They're not really doing their job, to be honest with you, but I have an appointment with community mental health in I'm sorry. I'm having a hard time speaking because I'm hurting, but in between 3 and 4 days from now, I have it on my discharge paperwork. If I looked at it, I can tell you the specific date. I think it's I don't know. I think it's a Wednesday or a Thursday this coming week. But if I go to the Mary Margaret house, I'm going to miss that appointment. So I don't know what you want me to do. I can do either or, but I'm going to struggle if I sleep in my truck for the next week. Luckily, I have gas for food, but
what I want you to do is contact community mental health. And if you need to change the appointment, you change the appointment, but you go to your appointment so they can help you find not only mental health treatment, but you can find housing. There's places in Otsego County that deal with people who have difficulty finding housing.
I've tried. United Way is closed, and that's the only place that helps with housing. NEMSCA doesn't help with housing, and that's it. There is nowhere in Otsego County that helps with housing. I've called all the numbers. I even went to the Goodwill Inn in Traverse City, and they rejected me.
Because of your behaviors.
No. Has nothing to do with that. My behavior is fine, sir.
MDHHS,
sorry that you don't like it, but that's not the truth.
Ms. Brink, you need to stop when I start talking. MDHHS helps with housing all of the time. Have you made an application there?
Sir, I've made all the phone calls. They're not helping with housing. If you'd like me to prove it to you, I can give you the numbers and you can make the phone calls yourself. But they're not helping me with housing. Well, don't say something that's not true.
Ms. Brink, you still have a responsibility to apply for work, whether it's difficult or not.
And I am.
You have not, because you've not submitted those to the...
Yes, I have. I've been in the hospital.
Out.
What do you want me to do? You ordered me to go to the hospital. You can't have your cake and eat it too, sir. I'm sorry.
Chelsea,
and I don't care if you think I'm being rude right now, but that's the truth.
Yeah, please watch.
We're good. We're good, Mr. Brown. Thank you, though. I appreciate that.
No, you need to let my attorney speak if he's going to defend me. That's his job. You ordered for him to represent me.
Ms. Brink, what he was going to do was tell you to be quiet, not me to be quiet.
No one needs to be quiet. There's no reason for that.
Say what?
Ms. Brink,
We're having a conversation to figure this out. Maybe if you hadn't taken my kids from me in the first place, we wouldn't be in this situation. There was no reason for that either, to be perfectly honest with you.
When did you go to the hospital? When did you go to the hospital?
The first time I went to the hospital was June 2nd because I was so suicidal because I'm homeless that I wanted to literally kill myself. And they put me in Sheboygan Hospital for 2 weeks, let me out, sent me to CREW, which is, which I don't know what it stands for. I can't remember right now. Crisis Residential Unit in Gaylord, and then they wouldn't accept me back for some reason because they didn't like that I went outside, and they said I went next door. And really, the honest to God truth is that because I wouldn't answer all their nosy ass questions, and so I went there. Not even for 24 hours. The cops came twice. The first set of cops left, had respect for me, and left. The second set of cops didn't. Handcuffed me, put me in the car, and took me to the hospital and said that they had a court order from you and that you wanted me to be checked out, and so they sent me to Munson. And I just got out 24 hours ago. So I'm sorry that I haven't put job applications in, but I'm in a ton of pain. And I will.
All right, good. We're going to adjourn this for a month. You're going to do the
Jesus
2
Christ.
applications
You
a
just don't
day,
give
10
it up.
applications a week to the friend of the court. We'll have another
I'll do as
hearing. in a-
many as I can, but I'm not going to waste my gas when I'm not getting hired.
Ms. Brink, that's a court order. If you're not going to do a court's order, you're going to be in contempt of court.
Whatever.
All right. Ms. Kraus, would you please make sure that that's in the next court order? That's all for today then. Thank you very much. Ms. Brink, you have one more case, so you need to stay on the line until that case is called.
Your Honor, could you
It's the
repeat,
same fit.
the amount
the
of job
exact same-
application?
Yeah, please mute Ms. Brink. All right, Ms. Kraus, the order is that we adjourn today's hearing 30 days and that she submit 2 applications per day or the equivalent of 10 applications per week, just like the previous order.
Thank you.
And then we'll simply have it reviewed in 30 days. Thank you, Mr. Hildebrandt. That's all for you today. You're free to go.
Can we, I got a question, Your Honor.
Go ahead.
The last hearing that we had that I was not allowed in on, I know Miss Kraus brought up the fact that she had sold her home and that it just got overlooked in the last hearing. It was mentioned and then nothing else was said about it. She had plenty of income to pay a little bit of her child support or some of her child support when she sold her house for $30,000.
All right,
You know,
Ms.
it's
Kraus, do
just
you have any
like-
other information about that?
Outside of, it wasn't at the last hearing. Unfortunately, I wasn't present for that. I believe the other case manager handled the Mays one, but in April, we did receive information. Let me just look at my last notes.
I don't recall that off the top of my head. That's why I'm asking.
I do remember there was conversation that we did have notification or we were able to see that that property was sold online, but we weren't able to find the amount. It was addressed, but I don't know exactly what had happened in regards to that.
All right, between yourself and the other case manager, would you assist me in trying to pull up some statistics or facts on that? Get me as much information as you can, and we'll review that again at the next court date.
Absolutely.
Thank you, Mr. Hildebrandt. We'll deal with that then, all right, sir?
Yes, sir.
And if you, Mr. Hildebrandt, if you have any other additional information, would you submit that to the friend of the court so that they can get that to me so we can address it on the record?
Yeah, I feel that it's always been just a blatant refusal for her to even pay any amount of child support, especially if she was just gifted $1,000 from her father yesterday. Should we expect a little bit of a payment? I understand that she's homeless and all, but that's by her own free will. She's the one that sold the house that was paid for. It's not a pity party for Chelsea today. It's, you have an obligation, you have children, support your children.
Yep, I understand that. But today's not the day for me to do that because I don't have all that information in front of me, and I'd like to have it before I make a decision. So we'll deal with it in 30 days. Thank you, sir.
Yes, sir. Thank you.
All right, the next case is Stanley Huffman versus Danny Marcinkowski. That's file 17-16885-DP. Either Ms. Marcinkowski or Ms.
I'm sorry, Mr. Hesslink, may I speak? This is Chelsea Brink again. You said to stay on the line and that I had to stay for the Mason case, but you've already moved on.
I'm calling another case, and I'll call your case, your second case, in just a minute, but it's not up yet. It's not its time yet, so you need to hold on until that case is called. All right, do we have Danny Marcinkowski or Stanley Huffman with us? All right, the next case is William Mason and Chelsea Brink, file 13-15199-DC. Ms. Brink, are you still with us?
Yes, I am, sir.
All right, thank you very much. I'm going to ask the friend of the court to update me on this particular case, and then I'll give you an opportunity to present your side if you wish. Go ahead, Ms. Spillane.
This matter was adjourned from May 30th, and similar to the last case, she was supposed to provide 10 job applications each week. Support obligation is $202 a month plus $50 ordered on arrears. Her current balance is sitting at $13,107.99, with the last payment received in May of $50.63.
All right.
I paid 2 payments of $100 each.
In April
And
and
like
May,
I
right?
said, I've been in the hospital
Yep, I remember that. Do you have any
and I'm
dollars?
homeless.
Do you have any dollars currently available to you to make child support payments?
No, I do not.
Did you receive, you mentioned receiving $1,000 from your dad?
I'm
Why
homeless,
is-
sir.
I'm sorry, I didn't hear that.
I'm homeless. I'm not
All right,
paying
but you-
child support when I'm homeless.
You have an
My
obligation.
kid's not
to pay child
homeless. He has clothing, food, toys, big screen TV, Xbox. He's got everything he needs. His dad does not ask me for money. I've called him, spoken with him twice, agreed to let me see him and talk to him. That still hasn't happened. Called him when I
Right.
got out of the hospital. He was one of my first calls. Didn't answer. Nothing needs to be paid. Technically, I don't even owe that because all of that happened when I was incarcerated for a year in the Otsego County Jail. So it needs to be remedied, to be honest with you.
Ms. Brink, did you sell your house in the last few months?
Yeah, and I was homeless, so most of my money went to hotel stays because my parents have dementia and can't understand that I'm homeless and need to move home.
How much did you receive from the sale of your home?
I don't remember.
Did you receive documents that told you how much you received?
No, I did
from the sale?
not. No, I did
find
not
that-
receive documents.
I find that hard to believe, ma'am, that you can sell a house. and
Well,
not
you
have
can if you want, but I did not receive documents.
Who did you sell the house to?
I don't know. It was a company.
Which real estate agency
And the
did
other
you use
reason
to
I
sell the
sold
home?
my house is because Brian Morgan, who you just spoke with a little bit ago, proposed to me when I was living at the sober living house getting treatment for alcoholism. And he proposed to me, said to move down there, that he could get me a job at Lucky Steakhouse. Did not follow through on that. I got a job at Italia Gardens, and then they fired me. And I did make payments when I was working at Italia Gardens. They took it out of my paycheck. I didn't even receive a paycheck.
Ms. Brink, which real estate agency did you use to sell the house?
I don't remember. I think it was Smith Realty or something.
What did you do with the money
So
once
the
you
only
received
reason I
it?
sold my house is because I was cleared out in Davison with no money, no job, no vehicle, no support from my family, and I couldn't get back up north to take care of my house.
What was the address of your
I
house?
didn't want
that
to
you
sell it. I had no choice.
Ms. Brink, what was the address of the house that you sold?
1336.
And when was the sale?
I don't remember. May something or March. I'm sorry, March something.
March of this year?
hmm
Do you recall who you sold it to?
No, I already answered that question once, Your Honor.
This is the turning point. The court independently verifies that Ms. Brink sold her home in March for $37,000. Until this moment, she claimed not to remember the amount, the buyer, or the paperwork. That lack of recall is legally significant. Selling a property generates documents, closing statements, transfers, deposits. The court doesn't need perfection, but it does expect basic awareness of a transaction this large. Now the issue shifts from inability to pay to use of available funds. Even partial payments from sale proceeds could have reduced arrears substantially. The judge doesn't rule immediately, but he orders documentation and signals a future show cause review. This is where consequences become real. The court is no longer just monitoring compliance, it's evaluating potential misuse of funds.
Your Honor,
Yes.
I just pulled it up on the county's equalization site. It shows that it sold March 25th for $37,000.
All right. Ms. Brink, I'm going to ask the friend of the court to prepare paperwork to send to you so that you can show cause as to why you've not made child support payments out of the funds that you received from the
I did. I
Sarah-
made 2 payments of $100 each. It doesn't matter that I didn't pay the entire arrears. I made payments, period.
I'm going to ask the friend of the court to send me documentation of the information that they have about the house and about the money that you received from the house, so I can determine whether or not you made sufficient payments towards your child support
No,
payments.
that's illegal. That's illegal. It doesn't matter that I didn't make the payments in full for the arrears. The state law says as long as you made an effort, and I did.
That's a good faith effort out of available resources is what the phrase is.
Yeah, and I did. That was all I could do. By the time I got back up here to make payments, the money was damn near gone.
You'll have an opportunity to show me that at a future hearing, but I want you to have the
I don't have
information
receipts
about
for
that.
anything, so how am I going to show you that, Your Honor?
You're going to have to tell me about it then.
I just did tell you. Now you're just being facetious, rude.
All right. You'll receive documentation from the friend of court.
You are an adult. You can hear me.
Ms. Brink, you're going to receive documentation from the friend of the court.
I have no
Setting it
mailing
for
address,
hearing.
so I don't know how I'm going to receive documentation. You'll have to send it to my parents' house, and I'll be lucky to get it. Like I said, they have dementia. I'm trying to take care of them. Very difficult to take care of 2 children, 2 baby dads, because that's what they are. They're not grown men. They're little boys. Men do not ask women for money, to be honest with you. Not in the world I grew up in, and probably not in the world you grew up in either, Your Honor. And I have 2 parents that I'm trying to take care of that have dementia and diabetes, both of them.
All right. Ms. Brink, that has nothing to do with child support matters.
But
What we're gonna do is-
that's all circumstances that are related to it that need to be taken into consideration.
At the next hearing, you may be right, but not at today's hearing. So at the
I
next
am right,
hearing,
Your Honor. Obviously, I'm right if you're adjourning it.
no, I'm going to adjourn this for 30 days so that we can have a review of 2 things. One is going to be whether or not you owe additional money from the payment to your house. And the second thing is we're going to adjourn for 30 days so that now that you're out of the hospital, you can continue to make your 10 applications per week. So we'll have a hearing in 30 days on both of those issues. The friend of the court will send out a notice to you of the requirement to pay.
How are you going to do that, Your Honor? You do not have an address for me. I do not have an address. I am homeless.
Where do you want me to send it so that you get that information?
Well, I'll be lucky to get it. If you send it to my parents, they might communicate it to me over the phone, but that's the best I can do. And she doesn't understand that paperwork, so she's not going to really explain it to me very well.
Okay. Ms. Spillane, do you have Ms. Brink's phone number?
My phone will probably be turned off. I'm going to try and make my phone payment, but it's only going to be good for another month, maybe. But it's 989. Yes, they do have my current phone number.
All right. Ms. DeFider, can we schedule a hearing next month right now?
The best way to communicate is through my attorney.
Jenny would have to do that, sir, because I don't know what your schedule is like. So Jenny sets those dates.
All right.
So your
She's
your
not-
next motion day would be July 11th is your next motion day with us.
Let's set it for that at 9 o'clock.
July 11th at 9 o'clock.
Yep.
Let me write that down before we hang up. And is that just for Bill?
That's for the 2 things that it's for both of these cases. So your case, with this case, which is with William Mason, and the other one is Devin Hildebrandt. Both of those cases will be set for 9 o'clock. The issues will be whether or not you've made sufficient payments out of the funds that you received, both from your father and from the sale of the house. If you disagree with that, you can file a motion. But I'm going to set it
I'm
for
not
that
going
kind
to be
of.
filing any motions because it doesn't need to be officially on paperwork, Your Honor. You're just being stupid now.
Ms. Brink, if you have an objection to what I'm doing, you must file a motion to object to it, or you can show up at the
Stop.
next hearing and
Just
make your
stop.
objection.
Yep. Okay. Go. Will you hand me my screen box?
Now go. Freak. Rah.
Are you Chelsea Brink? I have to hear from you, ma'am.
Yeah.
All right, thank you. I'm Judge Hesselink. I'm coming to you from the district court. You're here today because of an arraignment. There's actually two files, a new file and a probation file. Let me call those cases. First one is the State of Michigan versus Chelsea Brink, file 25-44174-FY-3. That is set for a new arraignment. And we're also here today on State of Michigan versus Chelsea Brink, file 25-44051-F3. That's a probation violation file. Let me turn to the first new file.
The case expands dramatically here. New felony charges, habitual offender status, potential exposure of up to 15 years in prison. This is no longer a family court matter, it's criminal court. The bond discussion is clinical and precise. Prosecutors cite violent history, probation status, and community risk. Defense points to homelessness and lack of resources. The judge weighs both but ultimately prioritizes public safety and pattern of behavior. The $10,000 cash bond is not symbolic, it's preventive. Combined with strict conditions, no substances, no weapons, mandatory mental health treatment, it reflects the court's assessment that supervision alone is insufficient. This moment underscores how repeated courtroom defiance can escalate consequences far beyond the original dispute.
With me today to assist in that is Richard Trush, defense counsel, and Mr. Fortier from the prosecutor's office. The new charge against you reads as follows. It says that on or about November the 18th of 2025 in the city of Gaylord, Otsego County, in count one, you did commit the offense known as police officer assault, resisting, or obstructing. It says that you did assault, batter, wound, resist, obstruct, oppose, or endanger Colton Huff, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. That is would normally be a felony offense with a 2-year and or $2,000 fine. However, you've also been charged as a habitual offender fourth offense notice, which has the effect of enhancing the sentence. That notice says that you were previously convicted of 3 or more felonies or attempt to commit felonies. In that on or about October the 13th of 2020, you were convicted of the offense of police officer assaulting, resisting, or obstructing in the 46th Circuit Court for Otsego County in the state of Michigan. On February the 5th of 2019, you were convicted of the offense of attempted arson, preparation to burn in the 46th Circuit Court for Otsego County in the state of Michigan. And on or about February the 8th of 2018, you were convicted of the offense of felony kidnapping, custodial interference in the 46th Circuit Court for Otsego County in the state of Michigan. Therefore, there is an enhanced penalty, and because the underlying offense has a penalty of less than 5 years, the new penalty would be up to 15 years in prison. Do you understand the name of count one to be police officer assaulting, resisting, and obstructing?
Yeah.
Do you understand the maximum penalty under the habitual fourth offense notice for that charge is now up to 15 years in prison?
Yeah.
I'm sorry, I have to hear something from you, either yes or no,
yeah.
ma'am. I'm sorry, I was not able to hear you. Thank you for making it a little bit louder. Count two reads as follows. It's entitled police officer assaulting, resisting, or obstructing. It says that on that same date and time, that you did assault, batter, wound, resist, obstruct, oppose, or endanger Jacob Depew, a police officer of the Gaylord City Police Department, who you knew or had reason to know was performing his or her duties contrary to the Michigan compiled laws. Again, that would normally be a felony offense of 2 years and or a $2,000 fine. However, you have also been charged with the habitual offender fourth offense notice that I just read to you on as to count 1. That now applies to count 2 to make that a felony offense with a maximum possible penalty of 15 years in prison. Do you understand the name of count 2?
Yeah.
Do you understand the maximum penalty for count 2?
Yeah.
All right. Count 3 is the name of that offense is Mail and Mail Depository Protection Act, also involving mail theft. It says that on that same date, time, and place that you did take, hold, conceal, or destroy mail addressed to another person, that is Lisa's Tavern, with the intent to deprive that person to whom the mail was addressed of the mail, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 1 year and or a $500 fine. Do you understand the name of count 3?
Yeah.
Do you understand the maximum penalty for count 3?
Yeah.
The final count, count 4, reads as follows. It says that on that same date, time, and place that you did commit the offense known as trespass, in that you did remain without lawful authority to remain on the lands or premises of Lisa's Tavern after being notified to depart therefrom by Elizabeth Arndt, who was the agent of the occupant of the lands or premises, contrary to the Michigan compiled laws. That is a misdemeanor offense. It has a maximum penalty of 30 days and or a $250 fine. Do you understand the name of count 4?
What is it?
It's called trespass.
Oh, yeah.
Do you understand the maximum penalty of 30 days and or up to $250 fine?
Yeah.
All right. You have certain rights, and I want to make sure that you understand those rights so you can decide what to do with them in the future. Your basic rights are you have the right to plead guilty, not guilty, or to stand mute. You have the right to have an attorney represent you, and you have the right to have a trial by a judge or a jury. At that trial, you would also have trial rights, which include the right to see, hear, and question all the witnesses against you, the right to present your own witnesses and evidence and get an order from the court called a subpoena to require those witnesses to appear and testify. At trial, you could also testify, or you could remain silent, and if you chose to remain silent, that silence could not be used against you. At trial, you'd also be presumed innocent until proven guilty beyond a reasonable doubt, and that burden of proof would remain with the prosecutor at all times. Finally, at a trial, you'd have the right to appeal any error at that trial. However, if you enter a plea in the future, you'd be limited to asking the court for permission to appeal, and that might not be granted. Do you have any questions about any of those rights?
No.
You believe that you understand those rights?
Yes.
All right. Mr. Trush, as to her right to an attorney, have you had a chance to speak with her about that?
I did, Your Honor. She has been screened and qualifies for counsel. Again, traditionally, I think she's been represented by Mr. Brown. I expect he'll be appointed in this matter as well.
All right. Ms. Brink, until you have a chance to speak, with your attorney, I'm going to enter a not guilty plea on your behalf in order to protect your rights. Because you've been charged with felony offenses, I'm also going to set some quick court dates to also protect your rights. The first date is called a probable cause conference. That'll happen in the next 7 days. That's a chance for your lawyer and the prosecutor to speak to see if they can resolve the case quickly. In addition to that, within the next 21 days, we'll set a preliminary examination date. Now, that's a short hearing in district court in front of me as the judge to determine whether or not the prosecutor can show a small amount of evidence called probable cause that you've committed the crimes that you've been charged with. That is not a determination of guilt or innocence. It is simply a check to make sure that there's sufficient evidence to proceed with the case. Do you have any questions about those two court hearings?
No.
All right. What we're going to do next is address the issue of bond. So I'm going to listen to both of the attorneys, and then I'm also going to give you an opportunity to tell me what it is that you want me to know before we make that decision. Mr. Fortier, as to bond.
Your Honor, I did submit a bond recommendation form. In it, I want to note that she is on probation currently in case 2544051-FY, where she was sentenced to 6 months probation on a retail fraud second degree and 2 counts of attempted resisting and obstructing a police officer. She was sentenced on October 17th, 2025, so just about a little over a month ago. I think based on the fact that she was out on probation for an assaultive offense. She's got assaultive offenses in her criminal history. She does present as a risk to the community at large. The court's obviously well aware of issues that Ms. Brink has. She's continuously picking up trespassing and R&O charges when the police are called. So based on that, I think a bond amount of $10,000 cash or surety would be adequate. I would also ask that, in addition to the standard conditions of bond, that the court order no drugs or alcohol be consumed, along with no marijuana, and that she participate in a substance abuse testing or monitoring program at the discretion of Community Corrections. Ask that she would report via Community Corrections, and that she participate in a specified treatment program, specifically with community mental health. I know she had indicated prior circumstances that she was involved with them. However, I'm not sure the extent of that involvement right now. I think it needs to continue, or at least be essentially restarted if it's not happening. I would also ask that she have no contact with Lisa's Tavern, that she not re-enter Lisa's Tavern, and that because she is charged with an assaultive crime, on top of the fact that she's got a felony criminal history, that she not possess any weapons or firearms. And that's it.
All right. Mr. Trush, your thoughts?
Thank you, Your Honor. In regards to bond on this matter, a few things that I think are important. Given the circumstances, we expect some amount of cash bond is going to be put in place here. I would indicate Ms. Brink has substantial connections to the community. She's essentially lived her entire life in Otsego County. I think the court is familiar with some of her economic circumstances. She reports that she's homeless. I know that she has reported that to the court consistently, I think, in other hearings, which I wasn't a party to, but happened to be present and observe. She reports that she struggled to get a job since being released from prison, with a felony on her record. She reports that it's disqualified her from a lot of jobs. She reports that she's always appeared. And again, I would just indicate to the court, I think that some cash bond is surely going to be put in place here. $10,000 seems high. I would suggest to the court a $5,000 bond is more appropriate. And I would suggest to the court, again, the court I think is aware of some of her other economic issues. And frankly, the fact that she has some other matters, which frankly, if she had available funds, I think would be more appropriately put to those than to a bond here. Thank you.
Ms. Brink, you do have the right to address me as to anything that you think would be important for bond. I would simply caution you that not to make any statements about the underlying facts of the case, because we are recording this and it could be used against you later. But if there's anything that you want me to be aware of, I'd be happy to listen to that now.
I'll stand mute.
All right. I do note, as the prosecutor indicated, that Ms. Brink has just recently been sentenced on a case that involved, at least in part, resisting and obstructing, or attempted resisting and obstructing police officers, the same offenses that she's now alleged to have committed on this particular case. She was on probation at the time she was alleged to have committed these charges. That she has ties to the community, but she has indicated to me in not only that previous sentencing, but in the other cases that she's been involved with the court, that she is homeless. I believe that she sold her home that she had here in Otsego County a couple of years ago, and used that money basically to stay in hotels for a little less than a year. She has not, to the best of my knowledge, had any long-time employment, if any employment at all, in the last year or so. So while she is well known to the court system, she has very limited things that tie her to this community, other than the fact that she may have people that she knows in the area. So because of her inability to keep herself out of trouble, and the fact that she is being violent towards our police officers, I believe that a cash bond of $10,000 cash and surety is appropriate in this case. conditions of release on that bond include personally appearing for all court dates set by the court, abiding by any judgment of the court, not leaving the state of Michigan without prior permission of the court, not committing any crime while on release, and immediately notifying the court in writing of any change of address or telephone number. She must also not use alcohol, marijuana, or any illegal controlled substances while out on bond. She must participate in a substance abuse testing or monitoring program through community corrections. She must participate in a specified treatment program for any physical or mental condition, including substance abuse, and that was specifically would be community mental health, and follow all recommendations of that assessment. She may not, because of her danger to the others in the community, she may not purchase or possess a firearm or other dangerous weapon while out on bond. She may not have any contact with, direct or indirect, with Lisa's Tavern. That means she may not call it, she may not show up in person, she may not use the internet or social media. No contact means no contact. Finally, she may not enter Lisa's Tavern in Gaylord as well. And then upon her release, she must contact Community Corrections within 24 hours of her release so that they may monitor her while she's on bond. Ms. Brink, do you have any questions about those bond conditions?
No.
Mr. Truce, anything?
No, Your Honor, thank you.
Mr. Fortier, anything else?
No, Your Honor.
All right. Ms. Brink, we also have one additional matter. Before I forget, Deputy, could you make sure that Ms. Brink gets fingerprinted on this new charges as well?
Yes, Your Honor.
Thank you very much. All right, Ms. Brink, we also have a probation violation issue. The allegations made against you on that is that you were charged with a new criminal offense of larceny, resisting, obstructing, and aggravated assault on 11/18 of 2025. That's the charges that I just read to you. I'm not sure if that's exactly the way it should be read, but you've also been charged with police officer resisting and obstructing, and trespassing, and mail theft. The recommendation is that you serve 93 days in jail and that you be discharged from probation with fines and costs preserved. Do you understand the nature of the allegation made against you?
Yeah.
Do you understand the recommendation as to what would happen if you were to admit or be found guilty of that?
Yeah.
All right. I'm going to assume that you wish to have an attorney represent you on that matter as well. Is that correct?
Yeah.
All right. And I will, because I've just heard that you have qualified for court-appointed counsel, I will appoint court-appointed counsel or send that to Mr. Gilo to determine who should be your lawyer in that. I'm going to enter a not guilty plea on your behalf until you have an opportunity to speak with your lawyer about that. And then we're going to set a court date in conjunction with your new felony offense so that they're both heard at the same time. I don't know what that date's going to be yet, but we'll have that done for you, and we'll send the notice to you at the jail or at the address that you give us as to where you want mail sent to. Where would you like to have notices and mail sent to, Ms. Brink?
I'm in jail. What do you mean?
If you get out, obviously, if you're in jail,
I'm not going to get out. I'm homeless. I have no job and I'm homeless. I'm not getting out.
All right. Does that mean that you don't want to have a mailing address to where you can pick it up from somebody else?
Right. I got no mailing address.
All right.
This case is a stark example of how courts balance compassion with accountability. The judge repeatedly acknowledged Ms. Brink's hardships, hospitalization, homelessness, mental health struggles, but consistently returned to one principle: court orders must be followed unless they are formally changed. Across multiple hearings, we saw a pattern of missed requirements, partial payments, and conflicting explanations. When financial resources surfaced, most notably the home sale, the court shifted toward deeper scrutiny. And once criminal conduct entered the picture, the focus expanded from compliance to community safety. The takeaway is clear. Courts can work with hardship, but they cannot work without cooperation, documentation, and respect for process. If you found this case as intense and revealing as we did, hit the like button, share your thoughts in the comments, and subscribe for more clear, no-nonsense courtroom breakdowns. We'll see you in the next case.